Minister. I'd like to thank the organisers for inviting me to moderate this session. They've landed me with 3 very good old friends and a new friend. Now that might cause constraints in my ability to maintain order in this meeting, but I would ask the speakers to stick to around 10 minutes so that we have time for questions. Now, they are very distinguished speakers. We're looking at the question of third parties. What are the obligations of third parties? What are their duties? The first speaker is Charles Shamas. If I was to give you a full account of Charles's career, that would exhaust the session. I've got to be honest, so I can only give you selected highlights. Charles is co-founder of the Matin Group, which is concerned with the enforcement of international human rights law and international humanitarian law. And this is taken from a multidisciplinary perspective. He was also co-founder of Al-Haq, which is the oldest and one of the leading Palestinian human rights non-governmental organizations. Coincidentally, our mutual friend, Professor Lynn Welshman, has just published a history of Al-Haq. This is being launched online on June 15th at 5 p.m. UK time, and I hope, give me a minute, I've just published a link to this event in the chat box. Having said that, the Matin Group has adopted innovative strategies to try and get the enforcement of human rights law and humanitarian law by third parties. I can really think of no one better placed to discuss the obligations of third states than Charles. So Charles, the virtual floor is yours.
Thank you very much. I'm delighted to participate in this. I'm very aware of the time limitations I have to respect, and so I'll get right into my presentation. I'm talking about third state responsibility, the responsibilities incumbent upon third states vis-a-vis the situation in Crimea and Donbass, surveying obligations emanating from IHL and IHRL instruments, as well as customary international law. And I'm supposed to provide a brief assessment of third state obligations in practice. For the sake of brevity, I will focus on an illustrative set of primary property-related IHL rules and on 2 codified self-executing peer enforcement state responsibilities that are critical to the protective effectiveness of IHL as well as IHRL. One of these is the external dimension of the undertaking made by the high contracting parties in Common Article 1 to the 4 Geneva Conventions to respect and ensure respect for the present convention in all circumstances, which was acknowledged as obligating individual states to induce respect for IHL by other states in Resolution 23 on Human Rights in Armed Conflicts, adopted at the 1968 Tehran Conference on Human Rights. This external dimension of the Common Article 1 responsibility has since been reiterated and reaffirmed by UN organs on numerous occasions. Another of these primary peer enforcement processes is driven by the customary duty of non-recognition set out in Article 41 of the ILC's Articles on the Responsibility of States for Internationally Wrongful Acts, as adopted by the UN General Assembly on 13 December 2016. And that says no state shall recognize as lawful a situation created by a serious breach within the meaning of Article 40, nor render aid or assistance in maintaining that situation. Now, on these two elements of state responsibility, or foundations of state responsibility, I would like to briefly propose the following observations. On the relevant primary international legal rules. The primary rules of IHL, IHRL, and other areas of UN law function essentially to define and distinguish forms of prohibited violence against persons, their habitats, civic life, and various forms of property and property relations. They delineate the positive obligations owed by states to rights holders. The first component of both the internal and external dimensions of the obligations they place on states and the accountability of states is to apply those rules diligently to distinguish conforming from offending exercises of power and the situations they create. Only then can states accountably determine and implement their obligations of respect, non-recognition, and ensuring respect. On the external dimension of the Common Article 1 responsibility. The widely voiced and entirely legitimate objections to states' niggardly performance and non-performance of the external dimension of their Common Article 1 obligations reflects both their complexity of the obligations as obligations of means, the current paucity of secondary enforcement rules, and the related indeterminacy of the standard of diligence on the basis of which findings of non-performance can be accountably, convincingly, and compellingly determined. In situations like those of Crimea and Donbass and the Israeli-occupied territories that involve a state's gross and systematic violations of international humanitarian law, international human rights law, as well as the prohibition on the use of force to acquire territory, it is more than reasonable to expect third states that command effective means to ensure respect, including effective sanctioning power, to utilize them lawfully by way of performing their Common Article 1 duty. However, I must defer further consideration of this problem, which can include deliberately ineffective implementation of proclaimed sanctions regimes, to another time. I will now turn to a non-recognition-based process of peer enforcement that is driven by three interlocked elements of state responsibility, anchored in a state's own internal rule of law interests. My examples will draw on states' respect and internalization of certain property-related rules, including the concept of territorial property, laid down in regulations annexed to the Hague Convention of 1907, Article 147 of the Fourth Geneva Convention, UN and regional treaty law. I will also draw on the need imposed by their conduct of external dealings to determine the internal legal effect they can give to activities and situations taking place in the Israeli-occupied territories under particular provisions of their existing internal legislation. And finally, I'll call on their need to place additional restrictions and conditions on external dealings with offending states in order to protect their own ability to fully and effectively implement their own legislation. In the examples that I will discuss, the EU and other third parties have found it necessary to take measures requiring Israeli external governmental and non-governmental counterparts that wish to participate in particular dealings to guarantee the conformity of activities and situations involved in those dealings with the primary international legal rules applied and respected by the third party, the EU, and other third states. Examples I have will relate to first funding of Israeli activities, okay, and entities in the occupied territories. This is an EU limitation. It was introduced in 2013. The second one, also related to the EU, is the restrictions that Europol had to enforce in order to respect its own obligation not to process information clearly obtained in violation of human rights. Okay. Now, this involved the first funding of Israeli activities and entities in the occupied territories involved the non-recognition, first of all, of the establishment under Israeli enacted legislation of legal entities in the Israeli legal entities in the occupied territories. And secondly, the non-recognition of the processes of appropriation and expropriation on the basis of which settlement property rights were created, Palestinian property rights destroyed, and on the basis of which activities financed by the EU conducted in facilities established in Israeli settlements would involve recognizing the conveyance of possession, use, and control to Israeli nationals as lawful, and would give effect to it by actually paying for the use of that property, okay? Paying the Israeli entities to which it was conveyed for the use of that property. In the case of Europol, the Europol and the EU found it impossible to conclude an agreement with Israel that would not ensure that the Europol could distinguish information obtained from residents of the occupied territories or in the occupied territories under a manifestly inferior and deficient human rights regime. Okay? And basically, the Israelis would not agree to that condition, and the agreement could not be concluded, and this process took several years to wind up. Okay. So in this case, it was in the non-recognition of the lawfulness and adequacy of the human rights regime applied by Israeli authorities in the occupied territories and to residents of the occupied territories, as well as to including residents of East Jerusalem. A third case involves the import of animal products. The relevant EU legislation requires that animal products must be produced on farms that are subject to the inspection of a recognized veterinary authority. Okay. They could not recognize Israel's veterinary inspection body as meeting that condition without recognizing Israel's application of its domestic legislation and extension of the authority of its domestic agencies into the occupied territories. A fourth has to do with social security cooperation. An arrangement that would basically involve coordinating Social Security administration and the provision of benefits, the administration of benefits that were linked to the status of the beneficiaries in the case of on the Israeli side as habitually resident in Israel. It meant basically that the EU found it impossible to recognize the status of residents Israeli residents settled in the occupied territories who have been transferred into the occupied territories unlawfully, illegally, as habitually resident in Israel for the purpose of the Social Security coordination. I think I run out of my time, and I just wanted to give a flavor to how this other mechanism works, and the fact that it is much more accessible to us, because the real problem is to get the responsible third state to actually examine and consider particular facts, practice, situations, exercises of authority, okay, and determine whether it can allow its own legislation to be applied and implemented in a manner determined by those unlawful activities and situations, policies, and legislation. So it's a pure non-recognition gambit. The difference is it doesn't rely on the customary international prohibition, which is limited to prohibition against recognizing situations created by violations of peremptory norms. In the history of my work, okay, I had to confront the fact that in the EU, one member state at the time, which refused to ratify the Vienna Convention on the Law of Treaties, refused to do it because it refused to recognize that there are peremptory norms of general international law. And the other problem was the lack of agreement about what constituted a peremptory norm. I remember member states saying the only peremptory norm that the EU would recognize, or we recognize, is the prohibition on international aggression, i.e. the acquisition of territory through the use of force. So I'll leave it there for questions. Thank you.
Thanks very much, Charles. We now turn to our second speaker, Dr. Valentina Azarova, who is a leading human rights academic and practitioner. She's also a research fellow at the Manchester International Law Centre. She's one of the founding members and a legal advisor to the Global Legal Action Network, which undertakes projects, in the field of human rights with a view to enforcing human rights obligations. This talk is based on an excellent paper which I've read. It deals with the responsibility of corporations. So it's over to you, Valentina.
Thank you, Iain, and thank you to the organizers for the invitation. I hope you can see my screen, as I'll have a few props to go on, as I also undertake a very heavy lift, since my task today is to provide a brief overview of the laws, policies, and practices that have, in the context of certain occupations, been relied on by third states, businesses, financial institutions, but also international organizations to socially construct a notion of an illicit economy of occupation. That is, in occupations that are characterized as predatory for being, for having an underlying claim to sovereignty, either through annexation or secession in ways we've discussed so far. This emergent normative framework is drawn from both international laws on third state responsibility, as Charles has just discussed to some degree, and on the business and human rights soft law blueprint framework for the implementation, of course, of international humanitarian and human rights norms to transnational business activities. But importantly, they are implemented in domestic law and transnational legal processes, again, as Charles has alluded. I want to also say that this is based, or these remarks, very brief highlights, are based on a longer paper with Dr. Antal Berkez, who's, I think, in the virtual room with us, and also, of course, on over a decade's worth of discussion and shadowing of the work of the Matin Group and with Charles himself. So let me start with our starting point, which Charles has set out to some degree, which is that in many contemporary occupations, ongoing occupations, the repurposing of land and natural resources for the use of the occupiers' civilians and for foreign businesses is closely linked with demographic engineering and is critically entrenched and legitimized through transnational business links with the occupier's economy. This includes investment, trade, natural resource exploitation, tourism, and so on. And there are several reports by Profundo, Somo, and others also in the context of the Nagorno-Karabakh occupation. I believe there are some reports on Abkhazia and so forth, of many different examples of such links, which I obviously cannot get into here. And as a matter of international law, the foreign territorial administration of such occupations is predicated on administrative and legal acts that amount to systemic and serious breaches of international law, particularly of peremptory norms. So this very much points us to the ILC articles on state responsibility, on third state responsibility. And that in this context make up the illicit economy situation. Sorry. These norms include, very briefly, as noted here, aggression, self-determination of people, denial of self-determination, violation of non-derogable IHL rules, but also racial discrimination. So it is therefore abundantly clear, and of course I crudely summarize, that any business that becomes involved in transactions related to such illicit economies benefits from the fruits of and contributes to the maintenance of an unlawful situation. This is again third state responsibility, by doing two things: predicating their activity on particular unlawful exercises of authority of the occupier in a number of ways, including payment of taxes and so forth, and using unlawfully obtained factors of production through titles and rights conveyed to such businesses or their partners in joint venture to control and use property, and of course make gains from such property, creating sustaining economic interfaces for the primary offending conduct, the primary violations of peremptory norms. Now, where does that lead us? As Charles briefly discussed, of course, the ILC's codification of the non-recognition obligation of third states directed at states and not businesses has the purpose of resisting the illegality of such situations by upholding the invalidity of various elements drawn out of these situations, which includes rights, titles, benefits discussed so far. The ILC did not provide enough guidance on the process by which non-recognition takes place, which is clearly a process, however, that entails domestic legal enforcement and transnational legal process. That is, this is expressed, in fact, in the negotiations and materials that led up to the articles on state responsibility, which clearly point to the obligations of states to refrain from granting follow-up and to ensure non-admission into the national system of these types of rights and benefits predicated on the unlawful situation, right? And of course, there are many shortcomings with this obligation. Most relevantly, again, the obligation is directed at states, not companies, but it has been extended, for instance, in the case that you see on the slide, which is extended to business activities, which is the case of some 18 government advisories issued in relation to business in Israeli settlements, which hold this recurrent passage. This is from the Irish advisory, but there are some 18 European governments and several other governments who've noted that financial transactions, investments, purchases, procurements, as well as other activities in Israeli settlements entail legal and economic risks stemming from the fact that the settlements are built on occupied land and not recognized as a legitimate part of Israel's territory. So this is very much in line with the non-recognition of Israel's sovereignty over the occupied territory. So it does follow that the scope of the obligation of non-recognition was not intended to be limited to interstate dealings, even if it is to be formally implemented in a top-down manner by the third state. I really simplify and move on now to some of the limits of the business and human rights laws, soft law framework, and its potential to activate transnational legal processes in ways that very much interact with the obligations under third state responsibility discussed so far. In establishing the UN database of businesses active in Israeli settlements, the OHCHR, on the back of years of advocacy, various briefs submitted, including one by Glan, SOMO, and FIDH, which I will put in the chat after my presentation, again, based on extensive discussions with Martine and Charles. The report of the OHCHR that came out in January 2018, and indeed the Human Rights Council resolution that preceded it, both arrived at a key determination in relation to the obligations of businesses in business environments such as the Israeli settlements. Namely that the nature of the impacts of business activities on human rights is immitigable. That is, that it is difficult to imagine a scenario in which a company could engage in activities in the settlements in a way that is consistent with the guiding principles. This is unprecedented and certainly an important standard that in many ways makes up for many of the limitations within business and human rights, soft law concerning due diligence and the preference given to self-regulation by corporations. What does this now mean? And of course, in Western Sahara, there's an equally interesting immitigability standard that has come about as a result of the European Court of Justice's decisions in the Polisario case, which of course I don't have time to discuss, but I just flagged. So what does this mean for, what does the structural illegality of a business environment mean for the responsibilities of home states under business and human rights law, but also under related obligations, which I have no time to discuss, which Charles has also alluded to, Common Article 1 and also Article 147 of the Fourth Geneva Convention to deter grave breaches. What it means, in my view, and in the view of leading rights groups and other lawyers, is that who have called for a ban on all trade with settlements, is that business obligations under the UN guiding principles, being of a prohibitive standard, require the third home state to assume certain regulatory duties, namely of a prohibitive effect. This means reversing the presumption of applicable law, which is a key problematic presumption of business and human rights soft law, but also of other transnational areas of law, such as civil litigation. But it also means critically assigning, and this is indeed what Charles was referring to as well, regulating business links with a prohibitive effect means ensuring that domestic law is applied to assign consequences of invalidity for the rights, titles, and benefits obtained from the illicit economy, right? And thus reversing the applicable law presumption that the applicable law in that economy is not that of the occupier, right? This is really to summarize. Now, final set of very quick examples here to bring that to light that we can pick up in the discussion refers to some real or ongoing case scenarios in relation to activities that have been or rights, titles, and benefits that have been deemed invalid in different countries as a result of them having been unlawfully obtained in the context of an illicit economy of occupation. So we have most notably the denial of rights to cargo shipment in South Africa, which was upheld by a court. We have growing attention to procurement law and the grave professional misconduct standard, namely in the Scottish government procurement note that refers to that standard being applicable to involvement in occupied territory, specifically in Israeli settlement. We have the judgment, again, of the European Court in relation to origin information that informs consumers about circumstances of production in settlements. And of course, with the Irish Occupied Territories Bill, we have a number of other countries interested in such special legislation, a growing awareness of the link between anti-laundering provisions to deter financial offenses that sustain grave breaches with, of course, the provision in Article 147 of the Geneva Conventions. So I will stop here, although if I have one more minute, I might also flag, in addition to the fact that there are several affinities between what the obligations I have managed to discuss so far and Common Article 1, Article 47, as well as Pillar 3 of the UN Guiding Principles in relation to access to remedies. And I would strongly suggest, and this is of course much more evident from the inductive and deductive analysis that Antal and I are conducting in the broader project, that the process of non-recognition is, as Charles has named it, a third-party enforcement process of a pre-adjudicative quality or character that can offer a general remedy to victims, right? So again, moving away from individuated remedies, which have been problematic and of course also restricted by the high thresholds of civil and criminal liability. And of course, the potential finally of consumers, procurers, and investors becoming the very political constituencies involved in transnational global governance in relation to such economies is also extremely promising in terms of this work and the burden of this work shifting from civil society to these constituencies in the longer run as a horizon to look forward to. So let me leave it at this, and thank you for your time.
Thank you very much, Valentina. That was a very clear discussion, and you've raised a lot that we can discuss in the discussion time. We now turn to Emanuela Gillard. Now, Emanuela is a senior research fellow at the Oxford Institute for Ethics, Law and Armed Conflict. She's an associate fellow of the Royal Institute for International Affairs International Law Programme. She was formerly head of protection of Civilians in the Policy Department of the UN Office for Coordination of Humanitarian Affairs. And before that, she was legal advisor to the International Committee of the Red Cross on the protection of civilians. So she is well placed to discuss the role of humanitarian organizations. The floor is yours, Manu.
Thank you very much, Iain, and thank you all. It's really been a pleasure to listen into these conversations for the past couple of days. The third parties I am going to talk about take us right back to the field. Before I launch into my presentation, like other speakers in the past couple of days, I need to point out I'm presenting the law, but I'm only very relatively familiar with the actual realities on the ground in Crimea and Donbass. So I'm really not in a position to enter into a factual discussion. So let's look at the law. What does the law about humanitarian relief operations say? The key elements are pretty straightforward. Primary responsibility for meeting the needs of civilians lies with the party that has control over them, state or organized armed group. If this party is unable or unwilling to meet the needs, offers to conduct humanitarian relief operations can be made. The consent of the affected states of the territorial state is required, but may not be arbitrarily withheld. There are two situations in which this state has no latitude to withhold consent. One is of direct relevance, it's situations of occupation. I'll come to this in a moment. The second are situations where the Security Council has adopted a binding resolution imposing relief operations, such as Syria. Once this consent has been obtained, all parties are under an obligation to allow and facilitate the rapid and unimpeded passage of relief operations, but may impose technical arrangements for this passage. How do these rules apply to the situation in Crimea and in Donbass? Let's start with Crimea. It's far simpler as a matter of law. I consider it to be a situation of occupation. The responsibilities are expressly addressed in the 4th Geneva Convention. Primary responsibility for meeting the needs of civilians has shifted to the occupying state. If there are unmet needs, this party has no margin of maneuver to withhold consent to offers to conduct relief operations. Importantly, though, it may impose measures of control. So, for example, it can decide which organizations are entitled to operate, provided that needs are met in an impartial manner. And it can also impose measures of control, such as searches, routes, and times. It's pretty straightforward, I suppose, as a matter of law. What about the consent of the occupied state? Is it required? Apparently not. The consent is required if the relief operations were to transit over territory still under the control of the occupied state. If not, its consent is not required. And I think this is just a manifestation of the suspended sovereignty of the occupied state. How has this worked out in relation to the Ukraine as a matter of law or in practice? And I have to confess that I found it very difficult as I was preparing for this to find any information on humanitarian relief operations being conducted in Crimea. I don't know whether it's an indication that there are no needs. I don't know whether there's an indication that it has been difficult to obtain the consent to operate there. As I said, I haven't followed closely. Let's move to Donbass, because I think this is far more intriguing as a matter of law, and more interesting if we don't go the occupation by proxy route that we discussed yesterday, and instead analyze it in terms of what does the law say if we have territory under the control of an armed group. And as I mentioned earlier, the law foresees two consecutive steps. First, the obtaining of the initial consent, and secondly, a subsequent obligation to allow and facilitate the rapid and unimpeded passage of relief operations. So, as a matter of law, primary responsibility for meeting needs lies with the party with control of the population in needs. And I'm just going to simplify and refer to the two de facto republics. They are the ones that have control of the population. So primary responsibility lies with them. If there are unmet needs, offers to conduct humanitarian relief operations may be made, but the consent of the state is required. Now, parenthèse, for now, there are a divergence of views among experts as to whether the consent of the state, in this case, Ukraine, would be required if operations could be conducted cross-border from neighboring states without transiting through the territory of the host state. I don't know if Michael Borta is still with us. We participated in an expert consultation discussing this among many other issues, and I'm just going to pop the outcomes of that consultations on the group for everyone. My view is that the consent of the state is required even for operations under parts of its territory that it no longer controls, and even if the relief operations do not have to transit through territory under its control. Quite frankly, this didn't seem to be so much of an issue in relation to Donbass. Ukraine did not seem to have any reservations about consenting to humanitarian relief operations being conducted in the two republic. Just for the record, I think it's interesting that right at the outset of hostilities, at a time when Russia was, in relation to Syria, insisting that the consent of the host state is always required, Russia itself conducted relief operations into eastern Ukraine without the consent of Kiev because it said needs were unmet. But that's history. At present, we are in a situation where we need the consent of Kiev. It has been obtained, and both sides are now under this obligation, all sides, to allow and facilitate and to impose measures of control. How has this worked out in practice in the area of Donbass? And I think in the summer of 2015, we saw a clash between law and politics. Yesterday, Yael kicked us off, referring frequently to the tensions that we see between the letter of the law and the political world in which we're operating. And this is an example of them. How? And I'm grossly simplifying. The two self-proclaimed republics in the summer of 2015 required the humanitarian organizations operating there to register with them. Is this problematic as a matter of IHL? I would say no, not at all. I see this as an acceptable measure of control. They are coordinating the actors that are operating in the territory under their control. I think it would be problematic if it was a way of limiting the response, but it's not problematic per se. What was problematic was that this was framed not as a registration, but as an accreditation. And this requirement, unfortunately, was considered through a political lens by UN leadership. And there were concerns that it could amount to a recognition of the claims of statehood or title to territory of these authorities. IHL expressly states that the application of the rules do not affect the status of the parties. We see this in Common Article 3. Nonetheless, the UN at highest levels claimed this was a violation of IHL and refused to do so, with the consequence that, at least briefly, UN agencies were precluded from operating in the two republics because they didn't manage to actually get the green lights to do so. Other actors can manage to continue to do so. Why? They were far more pragmatic and tweaked the language and referred to it as a registration. So they provided the information that was necessary to coordinate the humanitarian relief operations without going down this very political line. So I think this was a totally avoidable crisis. Let's fast forward to 2021, and this was the research I did as I was preparing for this seminar. Where do we stand now? A rather different situation on the ground. Key UN agencies are back in, so is the ICRC, and only a very small number of INGOs. Why? Because apparently the republics are not authorizing them to be there. So we seem to have got over this accreditation registration debacle, but now it is the republics that are, as a matter of practice, limiting the number of humanitarian actors that can operate there. Where does that leave us as a matter of law? And taking a step back, I think it really exposes the internal inconsistencies in the rules of IHL regulating humanitarian relief operations. I think that they are an odd arrangement that reflect the public international law framework within which IHL operates, because while it is only the consent of the state that is required as a matter of black letter law, both sides are then under this obligation to allow and facilitate a rapid and unimpeded passage. They're not equal operations, equal entitlements. In practice, though, by limiting the number of actors that are actually allowed to operate there, the republics are in practice in a position to decide, to be the ones determining, to be the ones whose consent is in fact required. So we're actually seeing almost an amalgamation of the two steps as a matter of practice. Is this problematic as a matter of law? Is this very limited registration of humanitarian organizations allowed to operate in the republics a violation of IHL? It is the rules regulating the obligation to allow and facilitate rapid and unimpeded passage that we need to look at. And these are not a bilateral obligation, a bilateral relationship between the party with control of territory and individual organizations. We need to take a step back and say, are the needs of the population being met? Are the arrangements such that the needs of the population are being met in accordance with humanitarian principles, therefore in a manner that is impartial and non-discriminatory? That's what we need to look at. And if the needs are in fact being met by the organizations that are operative, then the fact that it's only a small number is not problematic per se. Are they in fact being met? Who knows? Why? And this is an area where, again, I think we expose the limits of the law. It is actually very difficult, from what I understand, to have access to conduct needs assessments in the first place, to determine whether needs exist or whether they are being met in an impartial manner. So we find ourselves in this situation where, in practice, it is the republics that are determining who is entitled to operate, but we're not in a position to determine whether needs are being met in accordance with humanitarian principles. Thank you.
Manu. Thank you. And thank you, Manu and Valentina, for posting documents in the chat box. Now we move on now to our final speaker in this session, Raphael Marchetti, who's Professor of International Relations in the School of Government at LUISS in Rome. He's an external expert for the European Commission and for other institutions on matters such as global governance, public policy, civil society, and security. And today he is going to talk about the role of civil society. So it's over to you, Raphael.
Thank you very much, Ian, and thanks to the organizer for the invitation. It's a pleasure to be here. As you have understood by my introduction, I'm not a legal scholar. So I'm going to talk about a different dimension in the conflict in Ukraine, but more in general in conflict, intra-border conflict. Most of the talk so far has been on states, on international institutions. I think we need to focus on non-state actors, on civil society actors. They have become key players in conflict. And of course, this has been facilitated by the transformation of the conflict that are increasingly characterized by high intensity intra-border and often ethno-religious tension, but also strong international cross-boundary influence by proxy. So it is in this complex environment that non-state actors do play a very significant role on the ground, informally, unofficially, and yet very effectively, and yet having a very deep impact on many conflicts. If you want, as I said, I mean, this is the other side of the coin that we need to take into account if we want to understand what's happened and also how we can move forward. And of course, this is even more important in conflict in societies that are highly fragmented and deprived of a fully stable governing institutions. It is precisely in failing states, such as those undergoing ethno-political conflict, that much of the politics really unfolds on the ground. So we need to look at this micro level in order to capture fully the deep motives that trigger violence, and also those drivers that can help us to move forward and to stabilize, pacify, and reconcile a society. While in stable political systems, civil society may tend at times to apathy, in conflict-ridden situation, the mobilization may suddenly grow. Here, politicization is of a qualitatively different nature, as it occurs in view of the life or death nature of politics. So obviously, in contexts like this, the mobilization, the civic and non-governmental mobilization tends to be much more intense and much more effective. It is precisely the existential nature of politics and the securitization waves that are generated in society that trigger civilian mobilizations. When we talk about civil society, we should not only focus, obviously, on the classical NGOs, Western style that are accredited in the national registers of civil society organizations. Yes, of course, they are part of the picture, but we should have a much more encompassing views that range from local to international actors, from independent to quasi-governmental players. In fact, especially in conflict situations, rather than civil society, it would be better to use the term conflict society organizations. This is a term that Natalie Tocci and I coined some time ago, because the idea here is that civil society has this normative underlying flavor. There is civil, and then there is the uncivil society, the goods, the goodies, and the baddies. While in fact, in conflicts, the lines get blurred, and it's not always very easy to determine who is who on the ground, because identities and roles and functions change quite quickly. And Ukraine is a case, I mean, the protest began very peacefully and then turned into an armed mobilization, and the same people who were protesting peacefully after a few weeks or few months, took arms and weapons to protect their country or to fight for their cause. So the lines in every conflict gets very blurred. And so using sometimes the civil society, the term civil may be at times misleading. We're talking what kinds of actors? Well, of course, conflict operators, business, private citizens, research and education activists, religious-based groups, foundation, media. These are all important players in any conflict situation that needs to be taken into account. Of course, the context is very important, and we need to understand that really the first dimension or variable that we need to take into account is to what extent public institution, the state, is there effectively operating or not. Again, the case of Ukraine, of course, I'm talking about Ukraine in the past, not at the moment. Well, to some extent, I mean, now in the East is still the situation, but we need to remember that civilian organizations or post-Maidan organization ended up performing functions like security and defense, which the state has proved unable to fulfill fully on those in those times. Civil society became de facto a security actor, involved first in the provision of hard security with the establishment of self-defense units during the Maidan demonstration, and then of voluntary battalions following the beginning of the hostilities in the East. Second, civil society was active in the procurement of military equipment for the troops and the provision of logistical services like medical and clerical work, even at the front line. And third, in the monitoring and oversight of defense-related issues and military operation in Donbass. And not to a small extent. I mean, at some point, several thousands of organizations and civic formations were recorded officially by the Ministry of Interior, and almost 100,000 people were sort of involved in somehow armed related activities. So, because the problem is that when I would say the literature or the scholarly reflection think about civil society, they have this kind of very standard classic vision in which, of course, there is a state operating, and then there are some civil society organizations who cooperate with the state. But in conflict situation, the circumstances are very different. There, significant portions of state functions are then performed by non-state actors. And this complicates, of course, the picture. Of course, there is the nature of the states, how the states encourage or limits the action of civilian organizations. There are the socioeconomic conditions that matter, and obviously the presence, direct, indirect, by proxy, of foreign actors and of the international community. These are all important actors we need to take into account. What is also important when we think about the role of civil society or conflict society actors in conflict is their framework of action, how they sort of approach what kind of attitude they have toward the conflict. In fact, in conflictual societies, groups tend to articulate their subject positions in mutually incompatible ways. And I think this is, as you know, I mean, because you also work on conflicts, this is really the core sociological dimension that we should focus when we look at conflicts. Typically, a society in which the different components of societies, the different groups, ethnic groups, national groups, let's say, before conflict, this plurality of groups tend to see each other as mutually compatible. Think about former Yugoslavia. Serbian, Bosniak, Croats, they understood themselves as mutually compatible, i.e. they could live together. And in fact, mixed families were quite common. Then, through the conflict, the identity of the groups transformed itself and became a kind of mutually incompatible, i.e., well, no, it's not anymore possible that we live together. Each of us needs to live by his own. Now, unfortunately, this also happened in Ukraine. And so there was a deep and growing sort of identity demarcation in an exclusive way between the different components. And I think this is a deep structural sociological factors that we need to take into account. This is not at all specific and exclusive of the Ukrainian context, but of course provides a kind of stumbling block for the future. In fact, in divided societies, I mean, sort of these kind of ethnic conflicts remain at the center of politics, and ethnic affiliation or group affiliation become powerful, permeative, passionate, and pervasive, de facto dividing society and creating a situation in which public reconciliation becomes very different. There are some actors that tend to have a very important role, not always for the good, because they tend to keep this line of demarcation very neat. I'm talking about groups like the veterans, groups like the families of the victims, the family of the martyrs. I mean, you find this in all conflict situations. And these groups that are entirely, I mean, civil society or conflict society groups tend to play a very important role because they tend to preserve and continue the conflict sort of situation by sort of marking very strongly the group identities in an exclusive way. Of course, the appeal to external actors is very important and complicates, again, even more the situation. Diaspora communities always play a very important role, again, from a non-governmental perspective. In fact, diaspora groups are those who, in the different phases of conflicts, tend to exacerbate and fuel the conflicts by providing political support, political backing, financial support, sometimes weapons, and by encouraging a very divisive approach to the conflict. So also the scattered groups of people who are not living anymore in the country, who live abroad as diasporas, do play, despite the fact that they are not on the ground, do play a very important role in conflicts. And we need to take that also into account. What is also important when we look at civil society or conflict society organizations is also to understand what kind of attitude they have towards society. Assuming that at the core of any conflict escalation, there is this redefinition of the identities that tend to be framed as mutually exclusive identities, civil society organizations may have different kind of ideological perspectives. There might be civic or, in a way, post-national identities that have a more inclusive and egalitarian and non-identitarian attitude. There might be more multiculturalist non-government organizations, that while accepting the rights of all actors to an equal footing, equal stance, recognize and value their different cultural identities rather than attempting to transcend them. So while the post-national identities, NGOs or civil society organizations somehow, I don't want to say delete, but go beyond the identities, multiculturalist actors recognize the different sort of identities and trying to preserve them in a peaceful way. But of course, there are also other kinds of organizations that needs to be taken into account. I'm talking about assimilationist civil society organizations that accept the ideal of promoting an undivided society, yet in a non-egalitarian fashion. So de facto assimilating, integrating, and deleting the identities of the minorities. And even more, there are ultimately racist or ethnicist civil society organizations that have an exclusive and non-egalitarian outlook, believing in the primacy of a single kind of primordial linguistic or cultural or religious and non-assimilable identity. So again, when we talk about civil society, we need to have a broader perspective, not only looking at those that we assume are the goodies. They are important, but definitely they are not the only actors who play a role in the societies, in divided societies. And until and unless we adopt a perspective that is able to capture such diversity, we will not be able to understand fully the social dynamics that I would say do have an important impact on both the political and also the legal dimensions that we are discussing. Ultimately, if we believe that the inputs come from below, the orientation of these organizations will have an impact on the political orientation of the governments and also of other kinds of actors. So what is the dominant identities in Ukrainian civil societies organization at the moment? Well, I'm not sure. I mean, this is a very difficult question. I'm not sure we can answer this. I would say that there are still very different kinds of ideological orientations, and I think we need to come to terms with that kind of diversity. Okay, so with this I stop. Thank you very much. Looking forward to the discussion.
Thank you very much, Raphael. If you want to ask a question, please raise the hand icon in the on the gallery view. There has been one question or a couple of questions come in. One is for Manu, which came in from Nick Yurloff. Nick says, you mentioned there's a debate regarding whether the consent of the recipient state is required for humanitarian operations, even on the territory not controlled by it. What are the arguments against the need for consent?
Thank you, Iain. Are you passing the floor to me?
Yes.
Michael, are you here? I'm wondering if Michael Borta's still with.
I'm here, I'm listening, yes.
Shall we do the twin act, Michael? The pro and cons of is consent required?
Well, why not?
Please go ahead.
But you're the speaker, Manu.
Yeah, but you haven't been reading the messages in the box, Michael. We've been saying.
I haven't read the messages in the box, but I know what you think about it. We've discussed it before.
Exactly. No, and if we have time, Iain, as I mentioned, there has been an expert consultation on this question of whether in situations of non-international armed conflict, where relief operations can reach areas under the control of organized armed groups without transiting through the territory under the control of the state. very much the Syria situation, whether in those circumstances the consent of the host state is required. And you've got the yes camp, which is me, dinosaur as always, and the no camp, Michael, enlightened as always. So I'm going to give you the dinosaur, the very conservative position. And there are two provisions that are relevant. The first is Common Article 3 of the Geneva Conventions that only refers to the possibility for offers to be made to all parties, so the state and the organized armed groups. It doesn't actually say whose consent is required. It just says you can make an offer. And this is very important if, for example, we start looking at counterterrorism measures. If the group's designated, you can still engage with it. I feel that in view of the significant impairment of the territorial sovereignty of the state, that conducting relief operations in its territory without its consent would entail, I feel uncomfortable reading this silence as to whose consent is required as indicating that all you need is the consent of the party to whom you make the offer, so either to the state or the organized armed groups. The second relevant provision is Article 18 of Additional Protocol 2, and this is more explicit on this issue as it requires the consent of the high contracting party concerned. And my admittedly very conservative reading of the high contracting party concerned is that is a reference to the host state, to the territorial state. Therefore, its consent is required, even though the operations do not transit through territory under its control. Admittedly, it has a much narrower range of possible grounds for withholding that consent if the operations are for territory under the control of an organized armed group. And for example, it can't say, oh, I withhold consent because it would, for example, confer legitimacy or that kind of effect to the organized armed groups. And I emphasize again, as a matter of black letter law, as a matter of practice, I think humanitarian organizations always seek the consent of every actor that exercises any degree of control over territory where they conduct their operations or through who they transit, as a matter of basic safety and good programming. So that's one side of the argument, and Michael takes a different view.
Over to you, Professor Boten.
Well, thank you for permitting me to intervene at this point. You can even see me. Yes. Now, the point is this. Looking into the question of sovereignty, sovereignty is by no means absolute. And in the case of humanitarian assistance, you have a situation where sovereignty is limited by the facts anyway. And if you look at international armed conflicts, there it is a clear rule, the consent of the other party to the conflict, where the relief operation has no physical contact with, is not necessary. Now that brings me to the famous Article 18. And I was there when it was adopted. I'm sorry, old men tell old stories, but still. At the earlier phase of the conference, this is the result of the last minute plenary of the Humanitarian Law Conference, 77. In prior stages of the conference, a provision of what then became Article 18 was adopted, which was absolutely parallel to the provision which is still valid for the international armed conflict. The consent of the other side is not necessary, but the consent of the party in control of relevant areas, whether it's the area where relief is distributed or where relief has to pass through, is necessary. Now, for political reasons, it was politically impossible to mention the non-state party. And therefore, the non-state party disappeared in Article 18, although everybody knows it's not possible without that party's consent. And this leaves a certain doubt on the interpretation of the word consent. In the version of what became Article 18, just a second before the decision of the plenary of the conference, concerned meant the party which has a physical contact with a relief operation, transit, or the place where it's distributed. Has the change of the word concerned changed, has the meaning of the word concerned changed in the very moment of the adoption of the last minute? If I take the position of the delegate who proposed it, which was the delegate of Finland, then Secretary General of the Finnish Red Cross, peace be with him, I think he would wholeheartedly agree with me and not with a conservative view. It's a question of treaty negotiation, of negotiating history, but I think negotiating history can tell us a lesson about a reasonable interpretation of that provision. And thank you for the opportunity to renew our discussion. Thank you.
Thank you both. A question's come in for Charles Shamas from Helena. Helena wonders if, Charles, could you give an example of how such customary non-recognition requirements incumbent on third states in the external dealings could trigger the need to take specific measures vis-a-vis offending conduct, whether it's property related or not, in Crimea and or Donbass?
Well, let me just rummage briefly through my data points on Crimea and Donbass. And what I came up with is the following. First of all, as you know, the European Union has enacted legislation that prohibits imports of goods originating in Crimea or Sevastopol, okay, unless they have been exported with the consent of the Ukrainian government. In other words, a certificate of origin issued by that government. Okay? And of course, the same arrangement exists in for Northern Cyprus. Occupied Northern Cyprus products may only be exported into, or even put into free circulation within the European Union, okay, if they are exported via the Republic of Cyprus's authorities and with their consent. So this was simply a question of saying we have to respect the sovereignty of the Republic of Cyprus, and it performs its responsibility to enable trade to be conducted and economic life to continue in the occupied territory of Northern Cyprus, and the same with Ukraine. Now, the weird thing is that the member states have interpreted the regulation apparently as requiring them to inspect and check shipments of goods dispatched from Ukraine to the EU, okay? Not taking into account the fact, which is also kind of illustrated by the, made possible by the Kerch Strait Bridge let's say, facilitated by that construction linking Crimea to Russia, that goods are routinely transferred or transported to Russia and exported by Russian companies as Russian originating goods. Okay. So a particular senior official in the European Commission, when queried about this, said, well, you know, we wanted to proclaim these sanctions for their political effect, but we don't really care about their effectiveness. Well, then I was surprised to discover massive exports through Russia of Donbass anthracite to European Union countries. And of course, Crimean wheat is also being exported to several non-European countries, including Syria, Brazil, Saudi Arabia, and Libya, as Russian products. Now, the problem is in the EU, an importer has a duty under the customs code to correctly declare the non-preferential origin of the goods they wish to import. And member states were not really examining Russian exports. They were only examining exports dispatched from Ukraine. So this is a property-related example. Okay? If you drill down a little bit further into the circumstances of production of the anthracite, the transfers of property that have taken place, okay? The manner in which the production and the use of factors of production, including labor, are administered and controlled by the de facto authority in Donbass, the manner in which the wheat is grown, and let's say the land tenancy issues that may be applicable in Crimea. I haven't investigated this, but somebody should. Certainly NGOs should. And the question will be whether or not those goods can be not only lawfully imported with correct origin, which means requiring the Russian Federation and putting controls on the Russian Federation's exports. In other words, there are verification procedures, there are declarations on honor that can be used to require Russian exporters to indicate the correct origin of the goods, not as Russian. But also the question of whether or not the goods are improperly obtained. Have they been lawfully obtained by the exporter and the merchant in question? Now,
Rose, can I stop you there, please?
Okay,
so we can fit it. Thanks very much. That was very clear. I think you raised good questions. We've got time for one final question. One has come in for Valentina from Anton Makno, and he asks, are there any grounds upon which Ukraine can bring foreign companies that work in the occupied territories and pay taxes to the occupying authorities to legal responsibility? Could you make your answer quite brief, Valentina? Because we are nearly out of time. I'm sure we could run over a few minutes, but could you address the question, please?
It will be very brief, sneakily so, because I would need more facts to understand what the company's activities are, which jurisdiction it's in, and most importantly, what the domiciled country authority in a particular case may be examining that company's tax payments in the context of. So the dealings that require non-recognition or that have brought about processes of non-recognition, because we are in this deductive inductive logic with the state of the law here. It is progressing, it is being constructed in that direction, and the practice indicates that to some degree. Depends very much on what Charles would call the instigation processes civil society is behind, right? So, and in order to understand precisely the transactions in such a scenario, we would need a fuller account of the actors and norms and processes involved. So I'm happy to discuss offline further.
Yeah, I suppose in any legal question, the law is only part of it, the framework. We've also got to think about the facts. Okay, right. I think I should wind up here because, you know, we're 1 minute over time. I'd like to thank the panelists for their great contributions. Very, you know, very clear argument and very thoughtful argument, which is giving us food for thought. I'd also like to thank the organizers of this event and also the translators for trying at least to make me intelligible. I'll now hand over to Lena, please.
I just want to send a quick thank you to our moderators, panelists, Michael Bote, and all who joined in our discussions today. We invite you to join us again tomorrow for our international and domestic accountability panels. We'll start again at 10 a.m. in Kiev, 9 a.m. in The Hague, and 8 a.m. in London. Look forward to seeing you.